In my first term in the legislature, I was serving in the House. I served on the Law and Justice Committee. This was new for me. I didn't have a background in criminal justice. I was in the Marine Corps, then I went to business school and was an analyst. And I remember having a conversation with the chair, and there was some bill that was up that dealt with what the sentencing guidelines would be. I said, I don't understand, because why are we differentiating it this way? If somebody commits this, if two people commit the same act, violate the same law, why is the one who happens to have some circumstance associated with it penalized more when the other person maybe just didn't injure somebody else when they were drunk driving or what have you? They did the same thing. Shouldn't they get the same penalty? And he said, no, that's just not the way it's done. We always design our penalties based on what outcomes are. And it kind of opened my eyes a little bit to how difficult it is to try to find what a just sentence is. Because you look at certain crimes and you're trying to compare them to other, and it's a really imperfect process. And we are fallible people. We cannot come up with a perfect and just sentencing system. And even if we could, we wouldn't be applied the same way by every judge throughout the entire state. That was one of the reasons why truth in sentencing was established, because the justice was just so disparate between communities throughout our state. It's like, we got to have some minimum standard here. So I learned a lot, and it opened my eyes. I think I was an analyst. I was like, okay, let's get these numbers right. Let's get them balanced. Let's get some fairness here. And we're never going to get perfect at it. Do we have it perfect now? No. Can we make it better? Probably, absolutely. I appreciate the sentiment behind these. We want to find where there's imbalances and make it better. I can appreciate that. And looking into these bills, I see a history here that really needs to be considered. And we have a felony sentence structure that's based on all three branches of government play a role. Maximum term is set by the legislature. The minimum is set by the sentencing judge. The actual time is set by the parole board, which is part of the executive branch. And back in 1983, the Michigan Supreme Court created sentencing guidelines and required their use by an administrative order. The court used these guidelines for several years before placing less reliance and emphasis on their guidelines. This change in focus led to the legislature to get involved. And the legislature in 1994 established a sentencing commission with directions to develop sentencing guidelines. The commission met regularly for 2 years before releasing their recommendations in 1997. The statutory sentencing guidelines were enacted by PA 317 of 1998 to be used for all felony offenses. The enactment of the guidelines was tie-barred to the adoption of the sentencing policy requiring that offenders serve at least the entire minimum sentence known as truth in sentencing. The adoption of this legislatively created sentencing guidelines was considered to bring the system back into balance, with each branch handling their appropriate roles. The guidelines have been amended based on circumstances or more knowledge that comes to light or changes of opinion over the years. But then the biggest change happened in 2015 when the Michigan Supreme Court rendered the previously mandatory sentencing guidelines advisory only. This decision was called the People v. Lockridge. And it was applying the United States Supreme Court precedent, and the court held that Michigan's mandatory sentencing guidelines violate the Sixth Amendment. So now a sentencing court is free to exercise its own discretion to depart from guidelines without having to basically give reasons as to why they do so. So that's issue number one with why I'm opposed to these bills, because the judges aren't going to have to follow them anyway. They're simply guidelines. So the judge is going to have discretion to do what they want. We already have these guidelines in place. The second reason why I am opposed, if you look at the composition of this board, there's one individual that's going to be on this board that really stands out. And it's a formerly incarcerated person. I wish there was a victim or a victim's family member that held this place rather than an incarcerated person. And then this person's not going to have a voting authority, but they are going to have the ability to be present in these meetings and try to influence the decisions that are made in these meetings. And I just find it inappropriate. Why would somebody who committed a crime be able to then set what the standards are or help set the standards? That's backwards. It should be the victims that are helping set the standards. So those are the two reasons why I am opposed to this bill, and I encourage a no vote.